And then it gets into, if there's no spouse, then it's going to the children. And it's going to the children per stirpes. And then it gets down into brothers and sisters and mothers and fathers and grandmothers and aunts and uncles, and we keep working down. If you ain't got any of these, how about these? Any of these? No, how about these? And we keep working down until they find somebody.
Is this something you may examine us on?
No.
Okay, good. Thank you for that.
No. Now,
Do the chart. You to follow that.
the exact order, no. I might tell you that, ask you, how is property distributed if the guy doesn't have a will?
Yeah.
And you're going to say there's a statute of intestate succession in Florida, and it sets forth the order. Okay. Now, there's one more concept that likewise, the book says, happens only when there's no will. And they're wrong again. It's called escheat. E-S-C-H-E-A-T. And that's what happens if there's nobody to take, the property goes to the state. E-S-C-H-E-A-T, escheat. And that can happen if you have a will, but everybody died before you did. And here's what happens. If you have a will, and everybody died before you, well then your will is not going to transfer your property anymore. All the guys are dead. And if you didn't say per stirpes and there are no grandchildren, and you know, the point is, there's nobody to take under the will. Then we shift and go over to the statute. Okay, you didn't have a will? Well, let's go into the statute. And there's still nobody. We got all the way down through nephews, aunts, uncles, grandmother, grandfather, and all this, you know. Children of deceased nieces, it'll say. You know, I mean, they're really trying to give it to somebody. But if there is nobody, the property goes to the state of Florida. The point is, materials say that only happens if you don't have a will. It can also happen if you have a will, if everybody's dead. You live too long, all your beneficiaries died first. Okay, that concept is escheat. So yes, I would like you to learn what per stirpes and per capita mean and what the difference is and what escheat is. And of course, Florida has a statute, if you die without a will, of intestate succession is what it's called. Now we have testate succession. Yeah. Testate succession is you do have a will. Now, the materials say that a will is a written instrument that permits distribution. It doesn't permit distribution, it directs distribution. It says, my property shall pass to my son or to my daughter. The text goes into the 5 elements of a valid will. You don't need to know those. You're not going to draft wills for people. That's practicing law. A judge is going to decide whether a will is valid or not, not you. So I think this is silly to go through the 5, yes, sound mind, written, signed, witness, attested, and all that baloney. Yeah, witnesses in Florida, wills in Florida are witnessed and they're notarized. That's cool. But you're not the one who's going to be deciding whether a will's valid or not. Of course you're going to do that. But there are some important points I want you to understand. There is something in Florida called the spouse's elective share. And there's something like this in every state. Elective share. And this is the spouse's elective share. This is not the wife's elective share. The spouse. Somebody died and they have a spouse. Now, what this boils down to is simply, in Florida and in all these other states, you cannot totally disinherit your spouse. Period. You can disinherit your children in a will. You can say, I give absolutely nothing to my kids, and the courts will enforce it. I hated my kids, they were dirty, rotten, give them nothing. The courts will enforce that. But you can't say that about your spouse. You can say it, but the courts won't enforce it.
What's the name of this again?
It's called elective. The spouse's elective share.
Sharing?
Share. S-H-A-R-E. Share.
You cannot
What this
disavow a
means-
spouse?
I'm sorry?
You cannot disavow a spouse.
You cannot disinherit a spouse, yes. You can disavow too, but
Bottom 424.
Don't do it.
That you can do, you can disavow, you just can't disinherit. Here's what it
Page
means,
424.
loosely, and I'm an oversimplification here. If your spouse gets nothing under your will, or your spouse gets something and doesn't like it, the spouse gets 30%.
What?
30%.
Say it again?
30% of your estate.
If.
If you give them nothing,
Oh.
you have a will that leaves everything to your favorite charity. Humane Society. Nothing to my wife, nothing to my kids. Okay, the court will support the nothing to the kids, but the wife gets to take 30% before the Humane Society gets it. Now this is real complicated. They get into something called the elective share, and they get to bring in some things that are held by the entirety is not an issue because she don't all in, right? We're talking about stuff that was just yours. They bring in certain assets out of trusts, and they bring in certain assets out of survivorship for the purpose of calculating this elective share. And it's a whole concept, a whole, probate litigators do this all the time. They calculate this thing called the elective share, whatever that is. And that's debatable and that's arguable, but the spouse gets 30%. That's it. Now, I just want you to be aware of there is such a thing, and you cannot disinherit your spouse totally in Florida. Male or female, husband or wife, that's not what we're talking about, spouse. You need to understand what's going on in an estate. In Florida, we use the term administration. You've heard of probate, and that court chart I gave you even says the probate court is the circuit court. But we basically abolished the distinction between probate and not probate. In other words, probate used to mean with a will. We now have, we used to have two procedures, one called probate of an estate if you had a will, and the other one called administration of an estate if you did. We put them all together and called it administration. Florida no longer has probate. Florida only has administration. That's the proceeding to basically distribute your assets, whether you had a will or didn't have a will. Now, if you had a will, then the court's going to get into is the will valid and all that stuff, and the tests and will contests and et cetera. But if you didn't have a will, we're later going to distribute under these statutes. Yes, sir.
How does LBGT factors into the elective share?
What does, I'm sorry, what does?
LBGT.
Gay marriage.
I have no idea. I don't know.
I don't think it's legal in Florida, so they don't factor.
You know, we talked about that earlier with tenancy by the entirety.
Doesn't really mean you have to.
You know, is gay marriage going to count for tenancy by the entirety? I don't know. We're gonna have a court case one of these days, and we're gonna find out.
Right?
I'm sorry?
When you say spouse, you mean that you have to be married, or you just mean like living together?
It means married.
Okay, so
We-
don't, it's
I
not
think Florida has abolished common law marriage, I think.
Yeah, but they
It used to be, if you lived together long enough, the courts would declare that's a marriage, that counts as a marriage,
Right.
even without. I think we've abolished that.
Yeah.
But whether a gay marriage is gonna count, I just don't know.
That needs to be tested.
Yeah, that will be a court after an appeal, and you know how it'll come up. You know, a gay spouse will claim an elective share, and the person who got it under the will will say, hell no, you don't get an elective share, you're not a real spouse. And they'll butt heads, and then we'll have a court opinion.
And then he'll get 30%.
Or we'll have a tenancy by the entirety. And then the gay person will think I got it by survivorship, and the other heirs will say, hell no, that wasn't a real marriage. You couldn't have tenancy by the entirety. You know, so we'll have a case. But that's how people, it's remarkable how these things happen in the States, how different people butt heads fighting over an estate. When an estate's $2 million, there's lots of button heads.
What if when you get married, you got a prenup, but then you die? So who do they go
A
to?
prenup.
I mean, not a prenup. Well,
A prenup, yeah, that's what
prenup-
you do before you get married.
yeah.
Prenups often have provisions in them that say, in the event of the death, no matter what a will may say, that the spouse gets such and such an amount. But I don't know candidly if, for example, you gave the spouse on a prenup 10% of your estate and you died,
Right.
and then your elective share says you get 30%.
Right.
I don't know who wins it. I just don't. That's what the litigators do.
The prenup.
I just don't. I want you to understand what goes on in an estate, though. There are 2 or 3 important concepts I want you to be aware of. You have an administration of an estate. It's what we used to call probate. If you have a will, the court determines whether it's valid. If it is, then they're going to do what the will said. If they don't, you're going to do what the statute says, ultimately, later, when we get through this procedure. Now, the first thing that happens is the court appoints a personal representative. You need to know that term. That's a PR. A PR is a person appointed by the court to handle the estate. That's important.
Is that
If
person,
you-
I'm sorry, is that person the administrator, the executor?
It is,
Are those the
we
same
used to
animals?
call them an executor or executrix if you had a will.
Uh-oh.
And we used to call them an administrator or administrix, those are male and female,
Wow.
if you didn't have a will. We now call them a PR for everybody.
Forever.
That is the same thing as the executor you used to see on TV, or the administrator. In Florida, we call them a personal representative, and we abbreviate it PR. And we use the term a lot, you'll hear it. Who's the PR? Somebody just say, well, who's the PR? The reason you need to know who the PR is, that's who can sign contracts for the estate. That's who can sign deeds for the estate.
This PR
The
does
court
what?
appoints somebody as the PR,
Administer the.
and if you were gonna wanna buy property from the estate, that's who you're dealing with.
And that person is a lawyer? I would.
Is it going to be a lawyer? No, it's usually a family member. Yeah. Here's how it happens. When somebody dies, somebody who wants to be the PR petitions the court and says, Your Honor, he died. I'd like to be the PR. And then he has to say why. Well, either he had a will, and in his will he appointed me as the PR, that's a good reason. Or he didn't have a will, and I'm the spouse. Or I'm the sole son, I'm the only son. You know, and you come into the court and you say, Your Honor, I'd like to be appointed as PR. The court then sends notice to all the family and says, this person wants to be PR. Is that okay with you? Anybody who doesn't like it comes in and objects. After the objection period is passed, the court will then appoint the PR. The PR gets a document called, you need to know this, letters of administration. We used to call them letters testamentary. We now call them letters of administration. We've gotten rid of the concept of whether you have a will or don't have a will when you have this proceeding because somebody died called administration. So the PR gets a document called letters of administration. When you read it, you'll see what it does. It gives the PR the right to contract, to sue, to take action, to sell properties, to settle debts, to do all the things on behalf of the estate.
Can that person keep the property for?
Can keep the business going if he wants to, can liquidate and close the business, can sell property, can do anything he wants. Now, basically, and you don't need to know this, but just to understand, I want you to get the drift of what's going on. In my mind, there's 3 things a PR does. He assembles all the assets. Go find them all. You know, how many CDs does this guy have? How many pieces of property? Let's get them all. Let's get an inventory of everything. What do you have? Secondly, people have 90 days after a PR is appointed, just so you'll know this, to file claims. This is people who said the deceased owed me some money. I want to be paid. The PR's second job is to settle all those claims. His last hospital bill, his last credit card, all the bills that the guy left.
With some due diligence, I hope.
Some you publish in the newspaper. You're required to contact anybody you know about. If you're the spouse, you're going to know about most of these creditors. If you're the son from Idaho, because there's nobody else around and the guy lived alone, you may not know much. But the point is, yes, you have tried to find out who the creditors are and contact them and give them notice. But they have 90 days to file a claim because the newspaper has a publication, so-and-so died. You creditors have 90 days to file what it says. That's the second thing a PR does, is to settle claims. And thirdly, once all the claims are settled and everything, his job is to distribute the property. Either pursuant to the will, you know, give everything to my son, give everything to my grandchildren, give everything to the Humane Society, or if there wasn't a will, pursuant to the statute. To the kids, to the brothers, the sisters, and you know, whoever they are. But that's basically what he does. He runs a business, he takes over a business, he liquidates stock, closes bank's accounts, he sells property, he takes over the business of the dead guy. Yes?
What's his compensation? Nothing.
About 3% of the estate. Awarded by the court. Out of the assets of the estate. About 3%. Okay, now, what you need to know is this. If you were to try to buy a piece of property from the estate, if you go see in the tax rolls that property is owned by John Jones, and you find out John Jones is dead, the property appraiser shows it was owned by John Jones, and he's dead, you got to find his PR. If you want to buy that property, you're going to have to buy it from the PR, if the PR hasn't yet distributed it to the heirs. If he's already distributed it to the heirs, they have a deed. That's your record owner. But if the property is still in the estate, the PR is who you're going to deal with. And you need to ask him, that PR, show me your letters of administration. How do I know the court appointed you? Here's a copy of my letters of administration signed by the judge saying, I'm the PR for all the assets of Joe Blow, who's dead. Then you know you're dealing with the right guy. Yes, sir.
If your wife becomes
The PR.
the PR, and most of your assets, the majority of them are held in tenants by entireties, yet the spouse that died has a lot of debts, she's required to take those TBE assets, whether they be bank accounts or properties, to pay off the debts
No,
that were...
No, they're not in the estate. That's the whole point. They are not in the estate. Property that was owned as tenancy by the entirety, or as joint tenancy writers partnership, is not in the estate at all. Not even subject to the claims of creditors.
So she would take whatever assets were remaining that weren't TBE.
That were in just his name. That were in just his name, were tenants in common. She's already gotten the tenants by the entirety stuff separately outside the estate. Immediately, instantly, upon death, there's no deed, there's no nothing. A death certificate vests survivorship property instantly in the survivor, without any deed.
If she were to, for whatever reason, pay somebody because she wanted to, would that pierce that somehow? Like, just curious.
I don't
Okay.
think so. If you decide to pay a creditor, you know. Now, there's one more issue. If you're buying property from an estate, you got to make sure you're dealing with a PR, and you've got letters, and you're simply going to have to make inquiry to make sure the estate taxes were paid. Because estates over $5 million have an estate tax. And you just want proof they've been paid. Federal government gives you a release, so does Florida. Florida will actually give them a release, say, okay, estate taxes are paid, or estate taxes are not due, but it's something that you need to look into. The whole reason I want you to understand this is, in case you try to buy a piece of property from an estate, what do you need to do? I'm not trying to train you to be a PR or to be a lawyer and write estate planning documents. Just simply, if you're dealing with an estate, what do you care about? And you don't really care whether the will was given to all my children per stirpies per capita. That's not your problem. You're dealing with a PR. Now, once it's been distributed, the PR, in this case, here's what's going to happen. That house, for example, the PR is going to issue a deed. He's either going to issue a deed to 1 and 2, 50% each, or to 1, 2, 7, and 8, 1/3, 1/3, 1/6, 1/6. But to be a recorded deed, you have a new owner. You got to go deal with these guys now. We're talking about while it's still in the estate and hasn't been distributed yet. And that can be a year or two. That can be 10 years, depending on how complicated the estate is. Have lots of businesses to liquidate, you know, lots of property to sell. You don't want to distribute. Often, the PR doesn't want to distribute property like this. Think about the nightmare of putting title on these 4 people. The PR sells it. Cool, he distributes the money. This is writing checks, this is easy. Okay, yes, sir, another question?
No, no.
Okay,
I have a question.
yes, sir, sure.
Can I hire a probate lawyer to help me to deal with PRs and the probate states that I would like to buy? I mean, is that common to hire a?
I'm not sure I follow you. Can you have a probate lawyer do what?
To help you deal with the PRs and find the states that are under.
Can you ask a probate lawyer, do you have some estates that might want to sell me some property? Is that what you're saying?
Yeah, yeah.
I don't think they tell you for confidentiality reasons, but I'll tell you what they tell you.
Because
Here's what they tell you. They tell you to go down to the probate court.
Because
I look at all the estates down there.
because that's a public record, yeah.
Yeah.
Exactly.
What you're also going to find astonishingly quickly is the property appraiser's website, within usually a couple of weeks, instead of saying the property is owned by John Jones, it'll say estate of John Jones. As soon as somebody files an administrative action in court, somehow the property appraiser gets notice of it instantly and then changes the name on there to estate of so-and-so. So you may very well see, when we talked about who's the owner on the property appraiser's website, you may see estate of so-and-so. Sometimes it's there. It's getting quicker and quicker. This is all about the, the interchange of information between the probate clerk's office and the county recorder and the property appraiser, and all that stuff now flows through. You record a death certificate of John Jones, the
Exactly.
property
Yeah, yeah.
appraiser picks up the state, hey, he's dead,
Yeah, my question was, is there a person that could help you to deal with all that without you have to go to a courthouse and get the public records and all that?
I can't think of a way for you to shop dead people property.
Because yes, it's actually a good business. Many PRs are looking to get
Oh,
fast
well, let me
cash
tell you what
flow.
they are.
Certain
I
companies.
have been a PR of estates about a dozen times.
That estate.
The moment you're appointed, you receive letters in the mail from realtors like you wouldn't believe. It'll knock you down. Your mailbox all of a sudden has stack of letters like this.
I do.
Dear
I
Steve
see
Janestra,
letters.
I see you've been appointed as PR. I'm sure you're gonna have a lot of difficulty selling the property. I can do it for you. I'll give you fair dollars, I'll close fast, and I mean, so there's a lot of competition of people trying to do exactly what you're doing, but they're doing it based upon an estate was filed, and somehow they're reviewing them, and whether they got an in with a probate clerk, or whether there's something you can click on the clerk's website for estates filed today. Could be, I just don't know, but the information gets out really fast.
Yeah, you can get it online, but you have to pay for it.
Oh, okay, well, then they must be,
It's
because honest to
free now,
God,
you can get it, but you have to pay
there's-
$4.
there's a realtor in Miami who wrote to me, I was recently PR of my mother's estate to try to sell her house. This same address in Miami started with, I walk by the house every night with my dog, and I see there are no cars there anymore, you probably need help selling it. And then they go a next step of, I can tell you haven't sold the property yet, you must really be in dire financial straits, we can help you out. And this is some guy in Miami
And
who
they
swears he
handwrite it.
lives in the neighborhood and is walking the dog, He's always coming from the Miami address. And my point is, that's how ludicrous they get, but that's how competitive they are to try to make you think that you're selling the property to the neighbor. Like we talked about, before you list the property, you go talk to the neighbors, And,
You'll handwrite
so
the
it's,
letter, have somebody handwrite
there
the
are
letter.
people out there competing to do exactly what you're saying, but I don't know where they get their information, Somehow they're getting it quickly, because those letters go out in a week. You got to stack up, And sometimes people do need to sell the property. Sometimes the property the estate owns only a piece of property, and that's it. And the heirs need money. This guy died and quit bringing home the bacon, and the kids have no money. Sometimes they really do want to sell the property that fast, and they'll take a cheap price because they need it. And it's kind of sad, but vultures do very well there. Bottom feeders, can make some great deals because people, I'm not suggesting you're a bottom feeder. What I'm suggesting is that deals are made because people need money. Traditionally also, people used to need money to pay estate taxes.
Cause
They couldn't afford to deed the property to these people. They needed to sell it in order to pay the estate taxes, you know? So they would look for quick buyers who could pay the estate taxes so then they could distribute some cash. Because distributing this piece of property to these people doesn't feed them, doesn't pay their bills. They still want, want money, you know? Okay, that's about the drift of the 3 ways they can lose the property without it being your idea. Okay. I want to try to do the recording chapter. And I hope we can get this done, chapter 18. But it looks unlikely we're going to make it to chapter 19 on what happens to the closing. Recording, honestly, it's difficult for somebody like me who's been recording documents forever to understand how recording sounds like Greek to people. You know, like, what do you mean by recording? There are a great 2 chapters on page 434, 2 paragraphs, I'm sorry, on page 434. The introductory paragraphs that say that documents didn't used to be recorded. When you got a deed, you remember these deeds that we looked at? You got a deed from somebody, you took your deed home and put it in a safe deposit box. I own it, I got a deed in a safe deposit box. Clearly, people would lose deeds. There needed to be a way to document ownership. And the important part is the concept, and this is kind of a stretch. The materials say that the primary intent of recording statutes is to protect third parties by giving them constructive notice that a prior transaction has occurred. That's really, to me, that's hard to follow. But what they're saying is this. If A sells a piece of property to B and gives him a warranty deed, what if B doesn't record the warranty deed? And C comes along. C looks at the public records. A owns it. A may get to sell it again to C because B didn't record. Get money again. Because C looked at the property appraiser's website, says A owns it, checks the title, A owns it, doesn't know anything about B. Then C could buy it. What the materials are saying is, in order to protect C, that the purpose of the recording statutes are to give C notice that A has already sold to B. That's what they're trying to say there. But candidly, I had a hard time following through that concept too. The concept is protect someone who looks in the public records to give them notice that a prior transaction has occurred. If A gave this deed to B in the year 2002 and B didn't record it, and in 2004 C comes along, C needs to be able to look at the public records and see A's already sold it to B. That's what this is all about. And what gets real interesting that we're going to talk about in a minute is what if he does this 3 times? Because these 2 idiots didn't record. Who wins between B, C, and D? Whoever records first. D goes in and records his deed. That's tough for B and C. As long as there's going to be a small exception there. As long as B wasn't living there. You know, he goes out there, D goes out there and sees this guy B, he gets supposed to say, who the hell are you? What are you doing here? So I got a deed. Okay. Now you're not protected anymore. You know about the deed. These are the concepts we're going to talk about. But the whole idea is you record your documents. Basically, if you're B,
Yeah, $100.
the reason you would record your document is to protect yourself against C and D. You don't want A to be able to sell it again to one of those guys and have them record first, and then you're screwed. So they're really saying the purpose is to protect C. I say the purpose is to protect B. I want to record my deed so the whole world knows I own this, and doesn't go dealing with A anymore and getting fights and getting problems. You record your deed to publish and your interest in the property and to protect your ownership of the property. Yes, sir.
What if a deed gets destroyed or lost or misplaced?
Before you recorded it?
No, once you've recorded it.
Okay, we'll talk about the recording process in 2 seconds. And let me go ahead and talk about that. Here's what recording means. Recording means you take your deed or your easement or your mortgage or whatever your document is into the recorder's office. Here in Broward County, it's what we call the old Burdines building downstairs where the county commission meets on Andrews. And there are west courthouses too. I think there's one out west and there's Pompano North and Hollywood South or something. They're the different courthouses. The point is you go into the county recorder's office and you say, here's my original deed. Please record this. And you pay them a bunch of fees. You pay them a certain recording fees based on how many pages your deed is. And then you pay these documentary stamps that we're going to talk about later, you know, a tax based on your purchase price, which is $7 a thousand. We'll talk about that later. But the point is you got to pay all that stuff. We're not talking about what does it cost to record right now. We're talking about what does it mean. You hand the document to the clerk and say, please record this thing. The clerk microfilms the document. Bless you. The computer immediately enters it into the official records books and pages like we talked about up there on the top of the document. And then they hand it back to you. You get the original back right now. You didn't used to. Used to mail it back to you about a month later. You get the document back right now. To answer your question, once it's been recorded, if you lose the original, who cares? Makes no difference. You can go down to the courthouse to the clerk and buy a certified copy of that recorded deed, and it's just as valid as the original. Still a great idea to put them in the safe deposit box. We had a courthouse in Jacksonville burned many years ago, and all the records went up in flames. It was nice for those people who still had their deed, you know. But the point is, once you've recorded the original, it becomes a hell of a lot less important. That's the recording process. And we're going to talk about a few of the concepts that arise out of this, but that's what it's all about. And the reason you do that is, you're B, you record it. When C comes along, he ain't going to go deal with A, he's going to deal with you. You're the record owner. And if you didn't record, this guy may get to sell it to somebody else who might record before you, and you're screwed. Unless you have, you know, with some exceptions. You can't know about you. Yes, ma'am.
When you record it doesn't show like a couple months later? I mean, even if you...
No, it's instantaneous.
Oh, okay.
There used to be a big lag of a few months.
Okay.
We call that the gap. The gap is narrowing down to a couple of days, and that's the period of time the computers just aren't up to date on recently recorded stuff. This stuff now, when you record, the clerk picks up your legal description and enters that into the computer, and the computer posts, we call that deed to that legal description like now. And the property appraiser may be updated in a couple of days.
No, I think sometimes you update like a month later. When you go to the appraisal, the Broward, well, I know Broward, that it takes
The
like...
property appraiser's website, now they take a while because their job, you need to understand, all this stuff that I showed you about the property appraiser, the property appraiser is doing that for her own purposes, of sending out real estate tax bills. She's not doing it for you, and that's why you don't rely on their information as your sole source of title information. We're going to talk about that in a minute. Why you get titles examined and title insurance and all that other stuff. But it gives you a quick idea of what's going on that you can't find out by just looking at a piece of land, you know. And so, in any event, that's called the gap. The delay period is called the gap, and and it grows and it shrinks based upon how many documents. If 100,000 documents get recorded today, it may be 2 or 3 days until they're all posted, until you can find it. But on a slow day, stuff is up to date in a few minutes. If you have a title computer that goes in and accesses all this stuff.
I get it's recorded quick, but doesn't
Okay.
show on the appraisal months later, but it's recorded.
Well, I couldn't see it online for 3 months.
Yeah, but if you go to the court, you will see it. I mean, it's recorded, but it doesn't show until months later.
So these first 2 paragraphs, introductory paragraphs, are kind of good just to explain to you, why do we do this? And that the history of all of these recorded deeds, when we had A, B, C, D, E down here, that's all called the chain of title. And it's all recorded, and that's why you can find it. If people hadn't recorded this, you'd never know about it. Okay, now, the materials get into notice. And this is kind of complicated. And there are 3 types of notice. I'm just going to focus on 2 of them because the third one is so obtuse, I can't distinguish it from them anyway, between them. There's actual notice and there's constructive notice. The concept is this. If when you record something, you create notice to the world. My deed is there, the whole world is supposed to know about it. Anybody who examines the title and sees the deed to be, he's on legal notice, actual notice. He actually looked at the deed and saw them be owned. Okay? Anybody who didn't do that is on constructive notice anyway. The concept being anything that you should have known about, you are on constructive notice of it. To me, that's the simplest way to put it. You should have known B owned this property, he has a recorded deed. What that means is simply, if B has recorded his deed, if you see his deed, so you deal with A, so you deal with B, that's fine. You're on legal actual notice of B. You don't get to say, geez, I didn't look at the public records. I went and paid A anyway. I thought A owned it. C can't claim that if B has recorded. Whether C has actual notice of B, or whether he has constructive notice, because you are on constructive notice of everything in the public records, whether you go look or not. This is like that concept of you know you have to file an income tax return. They don't have to remind you. You know if you're going to deal in property, you better go examine the public records because you're on constructive notice of everything there. You're on constructive notice of every mortgage that's recorded on this property, of every judgment lien, of every mechanic's lien, of all these things we talked about. You remember we talked about they all had to be recorded? Here's why. So that when you go to buy this piece of property, you can examine the title and see all these things. You can see that A has already deeded it to B. And you can see 2 mortgages by B and 3 judgments against B. And all these things that are in the public records. Once you see them, you're on actual notice of them. Even if you don't see them, you're on constructive notice of them because you should have looked. There's an implied notice the book talks about. I don't even know what that is. In addition, there are 2 types of statutes, recording statutes, that I can't tell the difference between either, of race notice and notice. And these are all about the distinctions between who records first. Florida has a notice statute. Here's what the notice statute says simply. If B didn't record, and C didn't record, and D, 2 years later, did record, D wins because he recorded first, so long as he didn't know about B and C. What that means you win if you record first, so long as you don't have any notice of anybody else that has a deed in front of you who didn't record.
That's not
You get to
statute.
you get to be ignorant.
That's a statute.
I'm sorry?
That's race notice or statute, or the whole thing?
That's Florida.
Okay.
Florida is called a notice statute. A notice statute is simply the first guy to record wins, basically as long as he's innocent. That's what we're saying.
But wouldn't they argue that you should have known that somebody else had?
But they didn't record.
Okay.
Remember, they didn't record. You should, yeah, you definitely should have known if they recorded.
Okay.
But we're talking about they didn't record. Okay? Now, and you should have known, when we say you win if you record first so long as you didn't know about them, there's one way the law presumes that you know about them. If they're living there. If you take a deed from A, but there's some guy named B living there, you're on notice, you better find out what B's interest is. He might have a deed that he didn't record. If he does, he's ahead of you. But if the place is vacant, if A's still living there, you got no way of knowing about B or C, they didn't record it, you're cool. Taking a deed, record it, you're fine. If somebody else is living there, the law says the only exception to that you didn't know about it is you should have known about it if somebody else was there.
What happens when that conflict blows up? What are the consequences?
Well, parties are going to litigate for whose deed's any good.
Nobody else.
Parties are going to sue each other. A may be going to jail, for selling the part for fraud. But the point is, we're not really worried about A. He definitely doesn't own it anymore. He signed 3 deeds. He's out, The question is between B, C, and D we're talking about. D wins if he records first unless B was living there, he should have known.
Are there
And
real cases?
then the courts might protect B.
Are there real cases like that? Where some seller defrauded buyers like that?
Of course.
Oh, yeah, and conceivably has told him he'll take care of recording it for him. That's where they often happen. You, as the buyer, didn't make sure your deed got recorded. You left it to somebody else, and you assumed it was recorded. Wasn't, so he can sell it again. Yes, sir?
So the whole premise is that A sells to B, but B does not record the deed, and then A.
Say that again?
So the whole premise is that A sells to B, but B doesn't record, and then A sells to C, and C records.
Yep.
But B doesn't live there, so C gets the property.
C wins over B as long as B wasn't living there, because that would have put him on notice that B might have some rights. Or,
He recorded.
if he knew about B, if he thought, this is great, B's an idiot, he didn't record, I'll buy it for less. I'll pay half, and I'll go record, and I'll get to beat B.
That'd be
Not
tough.
if you know about B.
It's tough to prove that somebody knew about something,
Who's
but
gonna say they
You
knew?
know, all these things are if you
you
can
can find
prove it.
emails, you could
Uh,
correspondence. who
But
knows?
the law is saying, if he was living there, you should have known. You should have inquired. You're on constructive notices, you should go inquire. What's he doing here? All right, that's all about who wins. We already talked about the recording process. We talked a little bit about this, that the history of all the recorded documents creates what's called a chain of title. And the chain of title is what people are going to review to determine whether somebody has good title. We talked about acknowledgments. Here's what you need to understand can happen. And this is what creates some of the problems we're going to talk about in a second as it relates to title insurance and stuff like that. Mistakes can get made. You remember we talked about the clerk indexes that deed against a certain legal description so it shows up in the next chain of title? What if the clerk indexes it wrong? You got a real good recorded deed to lot 2, block B. and you did all the right things and you went down there and recorded it. And the clerk posted it against lot 4. And it doesn't show up in the chain of title. Those kind of things happen. In addition, and this is happening a lot now, deeds are being forged right and left. People are forging deeds. If you look at the public records, you don't really know what A's signature looks like. You just see a recorded deed from A. And there were 2 witnesses, and there were a notary that said it was A. But it doesn't mean it was. A forged deed is worthless. A forged deed is not a conveyance by A. If B bought from some guy he thought was A, and paid money and recorded, looks clean, but he doesn't own it. He didn't really get a deed from A. So you got problems that can occur even if you do record. If the clerk posts it wrong and it doesn't show up in the chain of title, if a document is forged, you got no way of knowing it, these types of things can happen. And we're going to therefore talk about title insurance and what title insurance can do to protect you against stuff like that. When you go beyond a sales contract and you're going to get ready to close, you remember we saw provisions when we looked through the contract, and we're going to talk about it more heavily in the next chapter. But you remember we talked about the seller has to show his evidence of his title, and the buyer has a certain period to examine that title evidence to decide whether seller's title is any good. The way that's done is somebody gets a hold of what we used to call an abstract of title, that we now call a chain sheet, that shows all the recorded instruments and has copies of all those recorded instruments. And the purpose of this is some professional is going to take a look at that for the buyer. The buyer's lawyer, the buyer's title company, somebody that the buyer hires is going to take a look at the chain of title to see, does the seller have a deed? Is the seller's deed good? Did he get it from him? Did he get it from him? Are the title good? How many liens are on there? How many mortgages? How many judgments? Somebody's going to do this title examination. Traditionally, what used to happen was an attorney would take a look at the title for you and would write you what's called an opinion of title. An attorney would examine that abstract and all those recorded documents and would write a title opinion to the buyer. Just like a judge. I am of the opinion that A owns it and there are no mortgages. Quickly, that became an inadequate method of getting you protected on titles. Sometimes the property was worth $10 million, and if the attorney was wrong, well, he ain't worth $10 million to stand behind it. It wasn't good for lawyers either, because when there were title problems, lawyers are getting sued. And what can happen, think about this one. Think about that forged deed we talked about. The lawyer looked at the title, he sees a deed from A to B, he tells you B owns it. But it was forged. How the hell do you know when you look at it? There's nothing of record that shows you what A's signature specimen looks like. Got 2 witnesses, got a notary, it's recorded, it looks like it was good. So attorneys in their opinions were basically guaranteeing that A's deed was good. He doesn't even know. He wasn't there for that closing. He's now dealing with B, who may have forged the deed from A. So somebody came up with the idea of let's create insurance to protect people against it. That's called title insurance. An underwriter, meaning a big fat insurance company, has agents who are little title companies that you go to, XYZ Title, writes a policy on First American or on Chicago Title or on one of the big underwriters, and guarantees the buyer's going to buy from B here, guarantees the buyer that he's getting good title from B. So that if later A shows up and says, what are you doing in my house? He's got an insurance policy to protect him against that. Or if a bank shows up and says, what do you mean you bought it from B? Nobody paid off my mortgage. Because the clerk posted it on the wrong lot or something and nobody even was aware of it. Title insurance protects you against stuff like that. It protects the buyer, and there's also something called mortgagee title insurance that protects the lender. Lenders, every institutional lender requires title insurance. What that protects them against is, C here that we just talked about is who's going to get an owner's policy guaranteeing that he owns the property. He's going to borrow some money from a bank. The bank wants a title policy that protects them, that they're getting a mortgage from the real owner, that all the B's and A's mortgages have all been satisfied, and that they're getting the first lien against the property. If it turns out they're in second position or in third position, they're protected. If it turns out A forged the deed, they're all protected. That's title insurance. I strongly suggest to you that you never even remotely consider buying a piece of property without getting a title insurance policy from somebody you trust. You can't stand the amount of the risk. It's too huge. You could have a total title failure. You bought innocently in this situation from B, who had a recorded deed, and A was forged. You got nada. You got nothing. You don't own it. And your lender doesn't have a mortgage on it. But if you got title insurance, you're both going to get repaid. You got to do it. It can be issued by your lawyer. It can be issued by a title company. But you got to have title insurance. The risks are too great. And let me tell you one more thing that it does that a lot of people don't think about. That's a complete title failure. That's a total, absolute, you got zip. But what if all this is for real, and when A bought this from Q back here, in Q's estate, there was a little heir out here. There was an heir who had a 1/6 interest in the property down here. And somebody forgot to get a deed from this guy. And later you're down here and you're C, and you're trying to sell the property to D. And D comes along and says, what the hell, what about this guy? Nobody ever got a deed from this guy. The title company will then undertake at its expense to go get that deed and find this guy and pay this guy. Or bring a lawsuit to eliminate his interest, to do whatever it takes to clean up your title so you can sell it. Or so that you can get a mortgage on it to a bank. Because if somebody determines that there's an outstanding interest, what I'm saying is C may still have title. C may have a good deed. This may all be valid, but there may be an outstanding title interest that they get involved. If that's the case, the title company will protect you against it.
Is it expensive?
I'm sorry?
Is it expensive?
No.
Say it again, I'm
Oh,
sorry.
expensive. I didn't know how much.
Well, you pay the premium one time at the time you get the policy. It only covers you for the amount of your purchase price. In this transaction, if you paid $200,000, you have a problem a few years later, yeah, you're only covered for $200,000. The fact that the house appreciated to $400,000, you're covered for your investment. Okay, there is one more thing in the chapter that I want to tell you. Forget it, we don't have it in Florida.
What?
It talks about a torn certificate. Certain states have it, we don't. This is like a car title, where a government bureau issues you a certificate, where the government bureau says you have title to a piece of property. We just don't have that in Florida. And you need to understand the only way that we deal with titles in Florida is to look at the chain of title and see if everybody did convey, and see if everybody's outstanding interest and all of their mortgages and liens are all paid off, so the good title is passing here, and then so that when you go to sell it, you can demonstrate you have good title, because, and if you can't, you wish you had a title policy to help take care of that interest in D, or even more so to help take care of the fact that B forged this deed from A, and when A shows up and says, what the hell are you doing in my house? And he wins. That's the whole point. A wins. Now, and we can get into adverse possession for 7 years and all that kind of, yeah, well, maybe, maybe not. Maybe it's only been 2 years. Usually it's only been a couple months, because these things all happen real fast before A shows up. Yes, sir.
What's the magic of 7 years? I hear you talking about in real estate, the same thing with credit bureau and all of that. There's a whole bunch of statutes that revolves around 7 years.
That's Florida legislature. That's what they think. It just is. Some states are longer.
The marriage.
Some states are longer. But in Florida, that's just the number they pick. You know, and Canada, they're on the same issue again. There's a lot of debate of why the hell do we have stupid laws like that? And why, and the justification is, we shouldn't let some guy over in Europe have a piece of property for 20 years and not do anything with it. Let's do something. Let's get somebody in there and occupy it and use it and do something. I think that's crap.
I think so too.
But it's what the legislature said. That's where we are. Okay, obviously, folks, we're not going to get to chapter 19, which is what happens at a closing, and a closing statement and all that. We'll do that next time. And we will do our last 2 chapters. I'll say this one more time. Skip chapter 20. Escrow closing. We don't do that. Chapter 21 is mortgages. We're going to talk a lot about that. Chapter 22 is agreements for deed. We'll talk a little about those. And then we'll talk more about mortgages in our last class before the exam. So we'll do the closing next time. Any other questions? Thank you.
No.
Any questions, period?
Oh, man.
All right, thank you.
Great.
We talk later about the project.
Did you not get in?
No, man, kind of talking about.